here. I'm Tim Gard, I'm the Chief Executive of the Nuffield Foundation, and love to have so many of you here in the room. And also we're joined by some people who will be joining us online too, which is great. And I think it's a tribute to Professor Emma Hitchings' research that you're here for a publication that in many ways could not be more timely. It's a really good title, is what I wanted to say about it. Here it is, Fair Shares, Sorting Out Property and Money on Divorce. Incredibly rare in the world of academic research to have a title that actually says what it's about. And so all more impactful for that. My role really is to give you a brief introduction to the context of this project as part of Nuffield's wider work. I'm then going to hand over to our chair for today's discussion, Professor Nick Hopkins, the Law Commissioner for Property, Family and Trust Law, and he will shape the discussion and the responses to Emma's research, and we'll have a really good conversation. Just a little bit about the context. Actually, ever since 1943, the Nuffield Foundation has had one principal object, which, in the language of the times, was the advancement of social well-being. And that I think you all know, we fund empirical research where the data have the heft to influence policy and practice. And our strapline, the use of evidence to change lives, is not a bad one. But at the same time, I think this is important, we do work to understand and reflect the experiences of those whose real lives are the stuff of that data. And so in recent years, we've shaped our entire research portfolio around three pillars: education, from the earliest years through to the transition from the world of school and college to the world of work; welfare, labour markets; social economic policy, a focus on place and on intergenerational issues; and the third pillar is justice. And in many ways, I think justice could be seen as the fulcrum of the Foundation's concerns, because if the administration of the justice system isn't working well, and people who are caught up in it lose trust and confidence in its mechanisms and its outcomes, then trust in public institutions and a just society must erode, and the spillover effects will seep into all aspects of social policy and public welfare. And that's why I think justice is a fundamental part of this triptych of education, justice and welfare, and how they together comprise a framing of social well-being. And of course, the common concern across all these three pillars is the family. And it's through hundreds of our grants, they come back to family life. It's changing nature over time and the varying pressures brought to bear on family structures. And so it's not surprising that family justice has been at the centre of our justice portfolio for many years. And that's also why we put £8 million now into establishing the Nuffield Family Justice Observatory. Now, of course, much of our work in family law inevitably deals with the risks of those, often the most disadvantaged, who are caught up in the system and the operations of public law. We should, and we are, equally interested in the record of private law and the pressures and consequences on individual lives, whatever their social circumstances, and the disasters that can happen. And that's why Emma's report is at the heart of our interest, because it signals our concern to understand the experiences and the consequences of people's contact with the legal process. And it also adds to really quite an influential portfolio now of our family law research focused on marriage and divorce in all its different aspects. It joins, of course, Professor Liz Trinder's research into no-fault divorce that led indirectly to changes in the law. And also to Dr. Rajnara Akhtar's recent study on non-legally binding wedding ceremonies. And I saw Rajnara recently, it's very good to see you here today. And then there's Hilary Woodward's work too, on pension sharing on divorce, a hugely important issue referred to here in this report, and actually quite under-researched. So it speaks also to our inequalities agenda, given the disparities that often affect women in divorce cases. So we know well the causes of income and employment differences between married couples, especially where there are dependent children living in the home. And this research helps us to understand how the dissolution of marriage and relationship breakdown contributes to that imbalance. But despite the fact that divorce is now commonplace, it's interesting how we've known frustratingly little about these processes by which divorcing couples settle their finances and the fairness of those arrangements, especially among the majority of people who reach agreement outside of the courts. And so this Fair Shares research, I think, addresses a knowledge gap which is really important, and in doing so, it not only highlights flaws within the existing system, but also challenges prevailing myths and assumptions about splitting assets on divorce and how they're split. And so this research is landing just as the Law Commission is reviewing the laws implemented half a century ago that determine how finances are divided between couples. So I hope the Commission will be able to make and is making good use of this work, because after all, it does add that much needed empirical understatement to the process, the outcomes and the experience of reaching a financial settlement, which of course is my cue for welcoming Professor Hopkins, who's going to be our chair. But before I do, I have to make the necessary housekeeping announcements. There are no fire alarm tests scheduled, so if the alarm does go off, it'll be the real thing. So follow the Nuffield Foundation staff instructions, evacuate the building by the nearest stairwell exit down there, don't use the lift, don't take your personal belongings with you unless it's safe to do so, and wait in the assembly point outside at 70 to 80 St John Street. Also, just in terms of the way today works, the first part of this event is being digitally recorded and will be available on our website and on our YouTube channel, but we'll stop recording after we've heard from our presenters and before we move into the question and answer session. Now, during the question and answer session, we'll invite questions both online and obviously from the floor. And to minimise disruption during the presentations, we've muted online microphones. You can hear the people there. They'll be turned back on during the Q&A session, so if you'd like to ask a question online, please just raise your virtual hand. And online attendees will also have access to the chat function, but please just use this to tag any technical issues such as you can't hear. We'll be taking photographs, we'll be posting images on social media, along with some headline information about the event, but we're not going to be naming anyone in the audience or attributing comments or questions to any individual. And so if you don't want to be included in the photographs, just let some of our team at the back know. So let me now hand over to Professor Nick Hopkins. He is a Professor of Law at Reading University, an honorary bencher of the Middle Temple, and he was appointed as Law Commissioner in 2015 and is there in that role until September 2025. And amongst other projects, he's led the Commission's work on updating the Land Registration Act 2002, technical issues in charity law, enforcement of family financial orders, and weddings law. So, as I said, we hope this work will be of interest to the Law Commission. You get it free. Indeed, the Commission is a key stakeholder in so much of our research. And we're very grateful indeed to Nick for agreeing to chair this afternoon, and hope he will find he's able himself to offer some reflections on behalf of the Commission on what it says. So I'm now going to hand over to Nick for the rest of the session.
Thank you very much indeed. I can answer the questions around hoping that this report is of use and of interest to us very clearly with a resounding yes. It is a genuine delight to be here for the launch of the report. It's a day that we have been very much looking forward to since we started our project. And it's a report that could not be more timely. So that, as you're all aware, we are conducting a scoping report on financial remedies on divorce and dissolution, and we aim to publish our report in September of next year. And our work is seeking to answer a fundamental question, to quote it from our terms of reference, whether in England and Wales, the current law relating to financial remedies on divorce and dissolution provides a cohesive framework in which parties to a divorce or dissolution can expect fair and sufficiently certain outcomes. In finding whether the current law provides fair outcomes, it's not surprising that our terms of reference direct us specifically to the Fair Shares report. It's not the first time that Nuffield-funded research has played such a vital role in one of our law reform projects. But it is, I think, the first time that a project has been named in our terms of reference as something that we will specifically consider, such as the centrality of the research to the work that we're undertaking. So I want to take the opportunity today to also thank the Nuffield Foundation for the essential role they play in funding research of such significance to us as law reformers. We know that while it's free for us, it's certainly not free for others. The need for evidence of how the law operates in practice is apparent. And from the start of our work, we've been clear that we need to understand how the law operates in ordinary everyday cases, as well as in those that reach the law reports. It's well known that the reporter cases do not greatly assist in understanding how the law works for most divorcing couples. The development of the Matrimonial Causes Act since 1973, and particularly from around 2000 onwards, has been largely judge-led. And those developments have inevitably been prompted by situations where there's been enough to fight over. The principles of sharing and compensation that are so familiar to us from the case law will be of no relevance to couples who are trying to create two households from one, where there is simply not enough to go round and meet their basic needs. It's unsurprising that there are so few reported cases dealing with average levels of assets, when previous research and evidence suggests that many couples do not engage with the law, even to the extent of seeking a consent order. A quick look at the number of applications for financial remedies orders for 2022, the last sort of calendar year for which they're available, shows that around 39,000 applications were made, of which around 30,500 were or became uncontested. But the number of petitions for divorce or dissolution issued in the same period was over 121,000. So if so many couples do not engage with the law at all, and of those who do, the vast majority settle by consent, what's happening in these cases? How are couples reaching decisions on their financial arrangements, and what decisions are they making? There's an evidence gap between what we know, for example, from the reported cases, and what's happening in the majority of ordinary cases. And by looking at the experience of the entire divorcing population, the Fair Shares report plays a crucial role in filling that evidence gap. It shines a light on how couples reach their agreement and on the agreements that they reach. In doing so, we hope that the report will also help us to understand how the law is working in particular areas. And to give just three examples that our terms of reference tell us to consider, the first is whether there should be a maximum period for spousal periodical payments orders. Secondly, whether wider powers are needed for the courts to make orders in respect to children who are over the age of 18. And thirdly, the treatment of pensions on the division of parties' assets on divorce. So I want to look at each of these areas very briefly and highlight what we hope to learn from the Fair Shares report. So the first of these issues, maximum term limits on spousal maintenance, is of course contentious. There are strong views advocating for and against the imposition of such a term, whether it's 3 years with exceptions for serious financial hardship as in Scotland, the 5 years in Baroness Deitcher's Divorce Financial Provisions Bill, or some other time period. But to properly be able to consider the merits of a limitation, it's vital to understand the extent to which these orders are being made. The initial engagement we've had with legal professionals suggests that there is considerable regional variation in the making of spousal maintenance orders. Some areas, and within those areas we've been told some judges, are more open to making them and to making them for longer periods than others. And so the Fair Shares report, we hope, will provide us with valuable evidence on whether and how the path to financial independence following divorce is being achieved. Secondly, in relation to children over the age of 18, society has changed dramatically since 1973. It's more common for children to go on to tertiary education and thus retain some degree of dependence into adulthood. Even children who do not go into tertiary education may remain financially dependent on their parents beyond adulthood and are likely to continue to live with a parent who has provided their family home. Put simply, more people are living with their parents for longer, and there is no cut-off at the age of 18 for children ceasing to be financially dependent on their parents, something I'm sure I don't need to tell anybody here who has children in that age group. The Fair Shares project will help us to understand how the financial burden of supporting children over the age of 18 has been borne and by whom. Thirdly, turning to the issues of pensions, the first Pension Advisory Group report in 2019 made recommendations for best practice concerning the treatment of pensions on divorce. That report followed after previous research, including the 2014 Nuffield study, Pensions on Divorce, had raised concerns about this area. That 2014 work noted that pension sharing orders were not being made in many cases where there are available pensions, and that offsetting was the most prevalent way of dealing with pensions, and that the outcome in these cases may particularly disbenefit wives who are then left impoverished in later life. Nearly a decade on, the Fair Shares report will provide an essential update on how couples are treating pensions today and on the consequences their decisions have. Divorce is one of the most stressful events in a person's life. It's a time of change and adjustment where emotions can run high. It's important for all those involved that the law smooths rather than exacerbates the process of uncoupling. And the Fair Shares report will provide us with a vital evidence base to help understand how well or otherwise the current law does so. So without more, I'll hand over to Emma and her team to talk about the report's findings.
Thank you. Right, well, thank you all so much for coming along today to today's launch, whether in person or indeed online. I want to very briefly introduce you to the Fair Shares team because it was, I have to say, an utter team effort over the last 3 years and then the 2 years in the planning before we started this. So Caroline, of course, is the social scientist on the team. Gillian here as well is the family lawyer. Susan and Jenny, unfortunately, are not able to make it today, but Susan is the statistician and Jenny was the fabulous research associate. So I would like to start off with a little bit of background about financial remedies. As Nick has just said, approximately, and it does vary over the years, approximately 110,000 couples divorce each year, but only around 1/3 leave the marriage with a court order, and the majority of these are by consent. The remainder are adjudicated. Now, we know something about the court financial remedies population through court file surveys that have been undertaken in the past, but we know nothing about the 2/3 of the population that do not go to court, the majority. So the aim of the research was to provide the first representative picture in England and Wales of how finances and property are divided on divorce. In particular, to include information about couples who do and do not use the legal system for their financial and their property arrangements. Therefore, the study had 3 research questions. The first, what are the financial and property arrangements that are made? So how are assets such as the former matrimonial home, savings and pension divided? How do divorcing couples arrive at financial and property arrangements? So what supports, for example, if any, do divorcees access? How effective do they find these? And finally, how did things turn out in the period up to 5 years after the divorce? Is the outcome perceived as fair? How do outcomes differ between different population groups? So in today's presentation, Caroline and myself, we're going to provide an overview of the data and findings in response to these 3 research questions. I will flag that the research report is 125,000 words long. So we obviously cannot provide all the detail that is contained within that rather mammoth undertaking. But I just wanted to highlight that if we have, there will be stuff that has been summarised today, and we will be focusing on the key findings. Okay, so the methods. The key difficulty for us from the initial design stages of the study was how to access the non-court population, divorcees who do not get any financial remedy order on divorce. The way that we eventually did this was by commissioning a bespoke large-scale survey filled out by the divorcees themselves. Now, the survey was carried out by the research organisation YouGov. This was done amongst divorcees, amongst its online panel, who had received their divorce in England and Wales in the previous 5 years. There were, as you can see, just under 2,500 online survey responses from recent divorcees, 2,415. The second stage was interviews. The interview sample was generated through a research agency who recruited individuals who, again, had been divorced in the past 5 years, and they were purposefully selected to ensure inclusion of our key groups of interest, for example, the court and the non-court population. There were 53 online interviews, each of which lasted approximately an hour. So, in today's presentation, first, Caroline will take over from me and she will present the data on the financial context in which couples went into their divorce. So looking at the length of marriage, age, their financial assets and their income, as that is absolutely crucial to understanding the financial arrangements that emerge at the end of the process. She will then move on to consider how the couple's assets were divided, examining the individual assets first, so looking at the home, the pensions, other assets and debts, before considering the overall asset split. Caroline will then hand back to me and I'll examine ongoing financial support, including both spousal support and child maintenance, before moving on to consider how things turned out in the period of up to 5 years after the divorce. Then, in order to respond to our research question about how divorcees arrive at financial and property arrangements, we're then going to move on to look at the process itself, including the use of lawyers and other forms of support or advice. And finally, after all that, we'll outline our conclusions and also some of our recommendations. So I will hand back to Caroline. She'll put herself on the microphone and I'll turn myself off for the next bit.
Thank you, Emma. Let me just work out how to put this in my pocket. I've got a deep pocket here. Great. Okay. So, as Emma said, I'm going to start by talking about, well, who are these people who are going to divorce and what did they have in terms of income and assets? So both their income and their earnings and their assets. So the first thing to do, though, before I get onto the money side, is just a few key relevant demographics. So it's really important to understand how long have these people been married, how old were these people, and how many of them did or didn't have children. Okay. Now, like all the charts that Emma and I are going to be presenting, the horizontal bars represent the percentage of divorcees in a particular circumstance. So here we've got 29% of divorcees had been married for 5 years or fewer. Okay, so pretty much the same design throughout the presentation. Okay. So looking at the top of the chart, the spread of marriage lengths is a reminder that people get divorced at different time points, in different points in their life course. So 3 in 10 people reported their marriages have lasted fewer than 5 years. But at the other end of the spectrum, we've got 1 in 6 who've been married for 20 years. Okay, and in terms of age, I guess the key point from here to point out is that the vast majority of divorces happen prior to retirement. Okay, we've only got 15% of divorcees who are age 60 and over. But apart from those people who are under the age of 60, there's quite a kind of a spread across the age groups. So it's happening, divorce is happening at many points in time. 2/3 of divorcees had children with their ex-spouse. So at the time of the divorce, we've got just over half who had dependent children, so under 16 or 16 to 19 in full-time education. Then a further 1 in 10 didn't have any dependent children, but they had some children who were of non-dependent age, so older children. And as Nick was raising, that's a key point that we've been looking at about what happens to those people. And one thing I haven't put on the chart but is worth noting is that of the people with dependent age children, over half of them had more than 1 child. And this is important when we're kind of thinking about the number of family members dependent on the financial pot that's going to be shared. So going on to who were these families in terms of, what were they living on prior to divorce? Okay, so this shows the net monthly household incomes the couples had to live on prior to separation. So what they had after deducting taxes, NI and so on. And this really highlights that during the marriage itself, many couples were already living on relatively low incomes. So you've got 1 in 6 had less than £1,000 a month to live on, and a further quarter had between 1 and 2,000. So going on to, well, what about employment and wages? And this is one where we've separated out what was happening to women and what was happening to men, because this had so many implications for what was happening after the divorce. Okay, so the top of the chart is showing the proportion of women in orange and men in green who were working either full or part-time at the point of separation. And the bottom of the chart shows the net monthly pay of those who were working. So our study is reflecting very well established findings that wives, particularly mothers, were less likely to be working full-time, they're more likely to be working part-time or not working at all during the marriage. And the female earners brought home less on average than the husbands who were in work. So this is really highlighting that women are in a more precarious financial position at the point of divorce. So is this got implications both for earnings potential in the immediate term and also for pension provision later on? And these are both points that we obviously want to come back to later in the presentation. Okay, so moving from income and earnings onto assets. So what did they have during the marriage that was kind of up for division in the divorce? Okay, so this first slide shows how many divorcees had their own, how many divorcees were in home ownership, and then of those who were in home ownership, then how much equity was there to divide after any mortgage was paid off. Okay, so 7 in 10 divorcees were in their matrimonial home was owned. So very often that was with a mortgage. So 50% of divorcees were leaving marriage with a mortgage, and then there were other people who also, part of those were in shared ownership, which obviously would decrease the amount of equity in the home. Then we've got 3 in 10 divorcees who were renters. So those people, it's like a different situation, they had no equity for division. And I'll come back to those later. Okay. So, because such a large proportion of the divorcees had mortgages or in shared ownership, as a result, the equity available in the home after any mortgage paid off was actually often modest. So we've got 1/3 of divorcees where the matrimonial home involved an equity of under 100,000. So, and if you look at the other end of the spectrum, we've got, tiny numbers of people who are talking about large amounts of money to divide after divorce. So we've got about 7% who say they've got over 500,000. So not a lot necessarily to divide. Going on to pensions. So pensions would be the second largest, or would be up there with matrimonial home in terms of the kind of largest assets likely to divide. Now, in 7 in 10 divorces, one or both spouses had a pension other than a state pension. So women and men were equally likely to have a pension, but men were more likely to have paid into it for longer. And as we've just seen, on average, they had higher earnings. So the differential isn't actually in terms of have you got a pension or not, is actually what's the nature and the size of that pension. So what I've concentrated on in this chart are the pensions that weren't yet being drawn. Okay, that's the vast majority of the pensions, about 82%. Okay, but the pattern is very similar if we look at those of people who are already drawing their pension. This is a pretty stark picture that women, where they had a pension, women's pensions were of a lower value than the men. Okay, so amongst women with a pension pot, 4 in 10 had a pot that was worth less than 50,000, compared to 3 in 10 men. And then at the other end of the spectrum, you've got among men with pension pots, 13% had a pot worth at least 300,000, compared to only 2% of women with a pension pot. So this finding is really highlighting the particular financial vulnerability for women, because their lower value pension pots are likely to impact on their financial security in retirement, particularly if they still have got dependent children and they take the main responsibility for that child post-divorce, which will mean that there will be knock-on effects in terms of being able to make up decent contributions in the coming years. Emma will return later on to this point down the bottom, but I think when we started this project, I remember people saying, you can't ask about pensions, people won't know the value of the pension pot. In reality, we've got an awful lot of data here, and really key data, but this is a stark finding that we've got so many people who actually don't know the value of their pension pot when they were thinking, going into the, well, this is post-divorce. So, but Emma will come back to that. Okay, so pensions in the matrimonial home, for most, is going to be the largest chunk of assets. But we also asked divorcees about any savings they or their ex-spouse had at the time of divorce, as well as any other assets, so second homes, cars, etc. And we asked about things in sole and joint names. Okay, so I guess the key takeaway from this chart is, again, substantial proportions of divorcees had no or few savings or other assets. So half had nothing or less than £5,000. And only 1 in 10 had £100,000 or more, above and beyond anything in their pension or anything in the equity of the home. Okay. Similarly, we asked a question about debts that they or their ex-spouse had, again in sole or joint names, and this was in addition to any mortgage they had on the family matrimonial home. 2/3 of divorcees had debts at the point that the divorce process began. Some of them were modest. 1 in 6 had under 5,000, but others had considerably higher debts that they had to think about. And 4% were owing over £100,000 or more. And when we asked about this money, what's the nature of this debt, there were a mixture of overdrafts and credit card debt, so that was about 1/3 of all debt, or mortgages on other places other than the matrimonial home, and loans, which is about half. So kind of a mixture of different things that they were having to navigate. Okay, so I've been talking individually about the assets that divorcees had, but the assets in the marriage. And what we've done here is to say, okay then, looking at the home, looking at the pensions, both people's pensions, looking at savings, minus any debts, how much money was there to think about and potentially divide in the divorce process? Okay, so this is the net value of any assets, deducting any debts. The overall median value was £135,000, including those who had nothing or any debts. So what we're showing here is quite contrary to the impression given by the media's reporting of big money cases. Most divorcees weren't living in lives of luxury during the marriage and had relatively modest amounts to think about dividing at the end. So we're seeing that 17%, nearly 1 in 5, had nothing or only debts, if you add up across their assets. Then you've got 3 in 10 had less than 100,000. And at the upper end of the spectrum, you've got 10% who had 500 to a million, and another 10%, another 9% who had $1 million or more. Okay, so in combination with the other charts, and then this chart, it shows that a large number of divorcees were constrained in constrained financial circumstances at the point they were going into their divorce. Okay. So that's what they had. Well, how did they divide it? Okay, so I'm going to turn to how these were divided between the divorcing spouses. I'm going to start with the home. Okay, so amongst those people who were owner occupiers, so the family home was owner occupied, the most common decision taken in relation to the home was to transfer ownership to one of the spouses. Okay, so about half of cases, the ownership was transferred to one person. 3 in 10 decided to sell up. Okay, and where there was a transfer, I haven't kind of split this out gender-wise, but the transfer was more likely to be a transfer of ownership to the wife, particularly if she was a mother. Okay, right. So there were 2 major reasons. If we think about firstly transfers, and then I'll go on to talk about cases where they were sold. There were 2 major reasons given for transferring the matrimonial home rather than selling it amongst the 53 qualitative interviews. First one was to allow the children to stay in the family home, at least part-time. Okay, so they weren't selling up and the children lost their home. The second was where it was the most practical option given the couple's financial circumstances. And those 2 reasons are highlighted by this quote. So this is the situation where the home was actually transferred to the husband. And the wife received approximately 70% of the equity. And this gave her a large enough deposit to then be able to get a mortgage based on her earnings. Okay, so this father said, what we didn't want was the kids to have 2 new homes in a sense. So we wanted to keep a little bit of stability. My ex-wife wouldn't have been able to afford to keep the mortgage repayments and everything. Affordability of the house, I could just about do it. So we agreed it that way. At least we've got the home and we're not just saying to the children, right, mummy and daddy are splitting up and you've got 2 new houses. Okay. So what happened when the house was transferred into the name of one person? So obviously, the house goes into somebody's name. What happens to the other person? Okay, and in most cases, when the house was transferred into the name of one person, the other person got a compensating payment. So they got an amount of the equity out of home. Okay, but in 3 in 10 cases, that didn't happen at all. And it literally, the house went into the name of one spouse, and that was the end of it. Okay. I haven't shown the gender split on the side, but it just to say that it's interesting that there was much more likely to have a compensating payment when the husband kept the home than when the woman. So the idea of the home going completely into the name of one person without any compensating payment was more likely when it was the woman. Okay. So going on to house sales, so remember I said about a third of cases where they decided to sell the house. So this is a comparable slide, this time looking at the percentage of the equity that a spouse got from the sale. Okay, and again, the main finding from here is this one here, that it was not the norm for an equal split of the equity. This only happened in a third of sales. Okay, so it wasn't a 50-50 split. Now this slide translates the percentages into value. So how much money did a divorcee get when their house was sold? And you'll remember earlier that I was talking about the amount of equity in the home, and it was relatively modest for a lot of people. And this is reflected in the amounts that divorcees received when the home was sold. So nearly 2/3 received under 100,000, a quarter were receiving under 25,000. And this is really important when we think about the capital assets. They're incredibly modest when you're thinking about how you're actually going to find a new home. Okay. So before we go on to thinking about moving away from houses, just wanted to come back to these people who were in rented accommodation. The matrimony home was rented, okay, the 3 in 10 people. So this isn't a question about money, it's a question about stability. Okay, so by the time of the divorce, only half of tenancies had actually been retained. But this was much more common if it was social housing rather than private housing, and it was much more common for where it had been retained for the woman to stay in the house rather than the man. So most of these cases, so where there was still somebody living there, largely it had been done formally, so about 3/4 had involved a change of tenancy agreement, but this was largely something happening between the tenants and the landlord. It was very, very rarely, 3% of cases was actually something that went via a court order. Okay, pensions, moving on to pensions. We found very, very low levels of pension sharing. Okay, so in only 1 in 10 divorces where there was somebody who wasn't yet drawing their pension, was there an arrangement for pension sharing. Okay. Pension sharing was more likely if it was higher value, if the marriage had been longer, if it was a man's pension and where there were children. But this is all within the context that we're only talking about 1 in 10 cases. Okay. And where there was an agreement that the ex-spouse would get part of the pension pot, then it was only 1 in 5 cases was there a 50-50 split of the pension pot. It was largely they were getting a much smaller proportion than that. Okay. Okay. So the reasons why pensions weren't shared came through from the qualitative interviews. And really, one of the things was that interviews were often expressing the view, and this has been found in early research as well, that pensions are personal. They're seen as personal to the individual who's making the contributions. So even when the option of pension sharing is discussed, this belief about personal pots can sometimes lead to decisions to offset the pension against getting, for instance, a share of the home. And this is what one husband had said in his interview. I'd been in the house and spent an awful lot of money on an extension of the house and things, so I didn't feel at the time that a 50-50 split was completely fair. I also felt at the time, in terms of what we put into it, each put into it all, that I should have something more. But I came down to splitting it 50-50 in the end on the basis of she then gave up any claim to ongoing part of my pension. Okay. Right. Just briefly turning to the other savings and assets and the debts that people had. Obviously, as I flagged before, there were relatively modest amounts for most people in terms of the savings and the assets they had, and this is reflected in how much people actually got. If there'd been a decision about how to divide any of the savings and assets, this is the amount of money that people reported getting. Okay, so 1 in 10 divorcees said nothing. This is beyond anything that got out of the home or anything about their own pensions or their ex's pensions. Further, 1 in 5 received assets of under £5,000. At the other end of the spectrum, we've got 1 in 6 getting £100,000 or more. Okay. Equal sharing was uncommon. Okay. It was generally, in the qualitative interviews, people talked quite a lot about ownership. So people were more likely to view that they could keep the assets that belonged to them. Okay, so only 3 in 10 divorcees reported dividing any assets, savings and assets, equally with their ex-spouse. Similarly with debts, this is the amount of debts, if it had been decided, the amount of debt that people said that they had taken on. Okay. Good that the amount of debt was relatively modest for most divorcees. So 3 in 10 divorcees took on So 14% took on nothing and a quarter took on less than 5%, 5,000. Okay, but we have at the bottom got quite a large proportion who are taking on debts of 500,000 or £100,000 or more. Again, when we asked in the qualitative interviews about the debts, they were generally allocated to who was liable for them. Only 1 in 5 couples said that they'd shared them equally, and men were more likely to have had the debt and to take on more of the debt. Okay, before I hand back over to Emma, I wanted to present one last set of slides. So I presented earlier the total value of the assets the divorcees and their ex-spouses had during the marriage. So adding up what they said about the matrimonial home, the pensions, savings, assets, debts. So we've done a similar exercise, is adding up the total value of the assets and debts that divorcees received from these sources. Okay, so when I say received, with a pension, it would be what they got from their own pension and what they got from an ex's pension. Okay. So using those two amounts, we've calculated the percentage of the total assets that divorcees received. And our primary finding is that equal asset sharing was not the norm. Okay, so we broadly put them into kind of, you know, percentages. So this one here is like 40 to 59%, where we're saying roughly equal. And we've only got 28% who said that they receive a roughly equal part of the sharing of the asset pool. Okay, so others received more, others received less, but it's interesting that we've got 6% who received nothing or less if they took on debts and end up with a minus amount, and 13% who said they got everything. Okay, how does that translate into the value of the assets that people walked away with? Okay, so this translates what we said shown before into monetary values. Earlier, the key figure I was quoting was 135,000 was the median value of all the assets people had. Given that, it is unsurprising to find that half of divorcees who had divided their assets received less than £50,000. Okay. So the qualitative data suggested that the reasons for divorcees sharing out their assets unequally reflected sometimes need, sometimes individual circumstances, and sometimes differing motivations, such as wanting a clean break. There wasn't actually a significant difference between men and women in the value of the shares they received, the pounds and pence, but the difference was in the nature of the assets they received. Women more likely to get more of the house, men get more of the pension wealth. Okay. The final thing I wanted to talk about, to end on, is just flagging the value of having a good pension when it comes to a divorcee's financial position post-divorce. Because overall, divorcees who themselves had a higher value pension, men or women, tended to do better financially than those with no or lower value pensions. Good. And I'm going to hand over to Emma now, who's going to go on to talking about ongoing financial support.
Lovely. Thanks, Caroline. Right, so my next task is to talk about ongoing financial support. So the issue of spousal maintenance has received a lot of attention in England and Wales over the last few years. Claims that the current law provides ex-spouses with or ex-wives with a meal ticket for life have been used as a rationale to suggest reforms which would limit the spousal maintenance period. However, our findings show that many couples, 40%, did favour a clean financial break. Furthermore, in the survey, only 22% of divorcees, so these are the grey bars in the second and third rows on the chart, reported having had a spousal maintenance arrangement at the point of divorce. By the time of the survey, this percentage had dropped to 14%. Now, a number of principal reasons came through from the interview data as to why most couples did not pay ongoing spousal maintenance. For many divorcees, the issue was simply not on their radar when going through the divorce. There was also the practical reality of affordability of having spousal periodical payments. There was also the desire for a clean break, the need to demonstrate financial independence from the other spouse, as well as domestic abuse issues, with the victim of abuse wanting to be away from the perpetrator and not wanting to communicate with them going forward. So when spousal maintenance was paid, for the vast majority of divorcees, that's 88%, arrangements were for a specified period, either defined by a particular event or an agreed number of years. Now, for most, 76%, which is the first bar on the chart, the agreement to pay spousal maintenance was anchored to a particular event. A quarter, which is the second bar on the chart, was to have an agreement until their children reached a certain age. The payment of spousal maintenance was also associated with a certain amount of vulnerability on behalf of the receiving spouse. So, for example, where spousal maintenance was paid, it was often connected with having or having had children, or with the recipient having an illness or a disability. Moreover, adjusting to financial independence by increasing hours of work is not straightforward for mothers who are still taking the major role in childcare of younger children. And for those who do go back to work, life may still be a struggle. So choices that were made during the marriage may have turned out to be unwise with hindsight. One interviewee told us that her ex-husband had earned a high salary, and she had changed to a part-time job to support him in his career. When they divorced, she was keen to get things done quickly and move on. So she agreed to split the equity in the matrimonial home equally. From this, she had paid off her credit card debts and car finance, and she had also drawn down part of her pension in order to furnish and decorate her new home. She had struggled to get back on her feet financially, and looking back, she told us if she wondered that possibly she could have pushed for a better deal. She said to us, "I know it's not Edith Blyton land, but if you can, just try and give the woman a little bit of leeway, because she's, you know, in a lot of cases, she'll be starting off again, and there's a lot of things to consider." I went out and got a full-time job, but like I say, to start again right at the bottom and to start at £18,000, and it took me years to sort of work up again. Do you know what I mean? To what I consider a decent salary to look after yourself. Okay, so that's sort of very quickly spousal maintenance, but now let's very briefly look at child maintenance. So a substantial minority, 2 in 5, that's 39% of divorced parents within the study, did not have a child maintenance arrangement or were still trying to set one up. This is the bottom 2 bars on the chart. So that's 39%, 2 in 5. For other divorced parents, there were a range of family-based and statutory arrangements, with few made via the court. As you can see, only 3% there made via the court. One of the main reasons that parents gave for not having an arrangement was that they shared the care of their children, so costs were split between the parties. Other reasons given were including affordability of payments and the paying parents' lack of willingness to pay. Now, for the majority of divorcing parents, sorting out child maintenance was something that happened in addition to, rather than as part of, the divorcing process. Those parents who were better off financially during the marriage were more likely than those less well off to have an arrangement. Now, while the focus of child support and divorce financial remedy policy is on dependent children of the family, the research also captured what divorcing parents pay, if anything, towards children who are no longer of dependent age. Now, although there is no legal requirement for parents to continue to support their children once they enter into early adulthood, the study found that the vast majority, 84%, of divorced parents who had children no longer of dependent age continued to support them financially at the point of divorce, and 69% at the time of the survey. So even a few years later, that proportion is still quite high. Mothers were more likely to have children living with them at home and providing support in that way, and fathers were more likely to be providing financial support. So it shows the difference in how they were providing that support. Okay, so let's now look at the circumstances up to 5 years after the divorce. Now, since most divorcees came out of the marriage in a worse financial position than they had enjoyed during it, The key question is, how far did divorcees manage to make up their loss in the years after the divorce? Okay. So, despite little difference in monetary shares received from the assets, at the time of the survey, women, particularly mothers, were significantly more likely to be financially worse off than men or fathers. Compared to men, women, except women, this is crucial, except women under 50 without children, so that's the key group where there was a difference. So compared to men, women, except that key group, were less likely to be working or working full time, more likely to be in receipt of means-tested benefits, more likely to report that they were struggling financially, and have lower household incomes. Now, so let's look at the income element on the next slide. Now, this slide shows the gross annual household incomes of women and men at the time of the survey. Now, this is in particular for the two groups where the incomes of men and women were significantly different. These were for parents with dependent children, that's the one group, and then the group of 50 and over with no children. Now, among parents with dependent children, this is the first set of graphs, and older divorcees without children, the second set, women had significantly lower household income than men. Then you can see with the orange bars being wives and the green bars being husbands. Overall, our data found that being a parent, especially a mother, and being older, especially an older wife, were associated with greater financial hardship in terms of the amount of income received. Indeed, younger women, unencumbered with childcare responsibilities, tended to do relatively well, in comparison with women who were older or had children. It is therefore parenthood, and particularly motherhood, that has the most significant impact in relation to meeting a divorcee's immediate financial needs and long-term prospects. But what about repartnering? Well, another issue we looked at was this. Parents and younger divorcees without children were more likely to have repartnered than those 50 and over without children. For example, 43% of parents with non-dependent children had repartnered by the time of the survey, compared to 22% of those aged 50 and over without children. What repartnering did was it softened the impact of a reduction in living standards after divorce for both men and women, but it appeared to have a larger, more positive financial effect on men. Okay, so those are the circumstances 5 years later that we found. So now let's look at the divorce process. So this slide provides, the next one, provides data on the use of lawyers' mediation and also making financial arrangements. So in terms of the use of lawyers and mediation, we can see from the text at the top, 56% of divorcees consulted lawyers at some point during the divorce. But only a third, 32%, used lawyers in relation to their finances during the divorce process, with slightly more women than men doing so, women at 34% compared with men at 29%. Fewer than 1 in 6, 17% of divorcees reported having tried mediation. In terms of the bar graph, so this is whether a financial arrangement had been made. Overall, 50% of all divorcees, the top chart, had made a financial arrangement either in full or in part. with a third of divorcees not seeing themselves as having made any particular financial arrangement at all, with 18% saying that they went their separate ways and 18% saying that they had nothing to divide. There are also a small proportion at the bottom saying they were still trying or they had given up. In terms of sources of information and advice, now, while lawyers are possibly and are perhaps the most obvious and most common source of legal advice, which were used by 4 in 10 of divorcees, 40%, the data provides a rather mixed picture of where divorcees obtain their legal information and advice. 29%, according to the survey, had used government websites, but perhaps of most concern is the finding that 12%, right at the bottom, said that they had sought no advice or information about their divorce. Now, as we are all aware, there is increasing amounts of information available on the internet. The government's own websites and signposting do an important job, with nearly a third of divorcees here saying that they had used them. But there is also a mass of undifferentiated sources of varying authority and clarity, and only a limited supply of free or nearly free, robust and accurate advice services. Now, interviewees used government websites for a variety of purposes. Some used them for gleaning basic information about the divorce process when they were in the early stages, whilst others made use of the online calculators that are provided to help work out, for example, benefit entitlements or child maintenance. And these were found to be useful, as shown by the first quote. As far as other websites were concerned, interviewees also told us that they had Googled to find things out and had found information from a variety of sources. However, there was also some caution and negativity too. One wife noted the problem of the sheer volume of information and whether one could trust the reliability of different websites. As was said in the second quote, the internet is so vast, isn't it? You can use them, but nothing is consistent. The information isn't consistent because it varies on a case-by-case situation, I guess. Right, so moving on to another element that we found, and also sort of from what Caroline highlighted at the beginning of the presentation, which really there was a lack of awareness of family finances amongst a significant proportion of divorcees. Over a third, 37% of divorcees not yet drawing their pension did not know the value of their own pension pot. And these are people who've been through divorce. This is let alone their ex-spouses. This is their own pension, let alone their ex-spouses. With women at 40%, more likely than men at 34% to say that they did not know. In addition, 10% of homeowners with a mortgage did not know what the equity in their home had been at the point of divorce. And again, these are people who've gone through the process. And likewise, 4 in 10 divorcees, 38%, felt that their knowledge of their ex-spouse's finances was bad or very bad. So this lack of awareness and understanding, particularly of pensions, came through from the interviews. Now, one husband who knew little about his own pension and nothing about whether his wife had one told us this. He said, "To be honest, I wouldn't have a clue." The interviewer asked, "You put in the survey that you weren't sure if your ex-wife had a pension apart from the state pension." He said, "I imagine that she has, yes. It wouldn't be very much. I didn't think about my pension, and a few years down the line, I didn't even realise, but I had automatically been enrolled. I'm not sure if ex-wife knows I've got one. It didn't get discussed at all. We're both pretty laid back, really." Another wife knew that her husband had various valuable pensions, but had no idea how much they were actually worth. She told us he's worth an absolute fortune when he dies, but if there's a way around him not giving me any money, he would find that way. So I didn't look into it. If you don't know what you're missing, you don't mind. So this lack of awareness and understanding in pensions fed through, as one might expect, into how, if at all, pensions were taken into account when couples sought to make their financial arrangements. So, how were arrangements reached? Now, of those who had come to a full or a partial financial arrangement, remember that's 50% of the sample, the majority of these arrangements were made by the divorcing couple themselves. That's the top two bars, 52%. Arrangements were reached with the aid of lawyers by 19% of participants, and that's the next two bars, and then through mediation, the next two bars, by 13%. Furthermore, the strongest predictor of using mediation was having used a lawyer. 28% of those using a lawyer tried mediation, compared with just 11% of those who had not. Our study therefore confirms what was already known in the wake of LASPO, that lawyers are the main and the best sources of information about the utility of trying mediation. So let's look now at the use of formal routes. We found that those with higher value assets were more likely than those with fewer assets to have obtained a court order. So, although the decision to have a court order was associated with total value of assets, the route to reaching an agreement was less associated with how much there was to divide. Instead, we found that mentioning fault as the reason for the ending of the marriage was associated with taking a more formal route in sorting out finances. Again, note that this was based on an open question of why the couple separated. So therefore, negotiating via lawyers and going to court for a judge to decide were both more likely to be associated with cases involving some form of fault, an affair, abuse, or other behaviour issues. So among those mentioning fault, 1 in 5, that's 21%, had settled through lawyers, and 8% had a final order from a judge. For those not mentioning fault, the respective percentages were 13% and 3%. Now, the reasons for using lawyers and for using courts in preference to mediation or other forms of dispute resolution were primarily concerned with a lack of ability to negotiate with the other spouse. And of course, this might be to do with the power relationship between the parties, such as domestic abuse concerns, or the refusal of one spouse to engage. This, of course, has implications for policy and is relevant to the question of who uses the court, whether it should, and also, of course, whether it should be mandatory to attempt mediation or other forms of non-court dispute resolution before being able to pursue an application to court, a matter, as you will all be aware, recently the subject of government consultation. So let's now look at the costs incurred in terms of the costs of divorce. First, whilst 2/3, 67% of divorcees incurred some legal or mediation costs in trying to sort out their finances when they got divorced, our interviews suggest that these may be related to the cost of the divorce proceedings and also obtaining the decree. as well as costs associated with the financial arrangements such as conveyancing for selling the matrimonial home or transferring title to one spouse. Secondly, for the majority of divorcees, the legal and mediation costs of divorce were comparatively modest. A quarter, 24%, had to find less than £1,000, with a further 1 in 5, 18%, having costs of between £1,000 and £2,999. For many divorcees, the main cost will be the divorce application fee itself, which as you can see, given the assets involved in income, is not an insignificant amount of money. We need to note, however, that 9%, this is this particular bar, incurred costs of £10,000 or more, but higher costs were associated with higher assets. Therefore, while very substantial sums can be spent on pursuing legal proceedings, our data shows that legal costs are not inevitably high. So the next 2 slides, we examine how arrangements differed between those who use legal support in relation to their finances compared with those that did not use legal support, as well as those who did and did not use the court to formalise their arrangements. However, it is important to emphasise at this point that this data is unable to show that the use of legal support or the process of formalising a court order causally led to a particular outcome. Instead, the data can only show correlation between particular outcomes and whether the divorcee had obtained legal advice or got a court order. So first, the study found an association between getting legal help and getting a better deal, particularly for women. So for example, where the home was sold, a divorcee having received legal advice was more likely to receive a higher percentage of the proceeds of sale. Over half, 56% of wives who had received legal advice received more than half the proceeds after sale of the home, compared with only 14% who did not. Also, men were more likely to share their pension if they had received legal advice. And women were more likely to receive ongoing financial support if they had received legal advice. There is also evidence from the data to suggest that women tended to do better where a financial remedy order was obtained from the court, whether that be by consent or adjudicated, and we know that the majority are by consent. For example, women were more likely to receive a transfer of the matrimonial home and less likely to make a compensating payment to the ex-spouse where there was a court order. They were more likely to receive over half the value of the home if it was sold. And they were more likely to obtain a share of their ex-spouse's pension. So whilst the study could not establish a causal relationship, it is plausible that lawyers who are advising clients are encouraging them to bargain within the shadow of the law to arrive at arrangements likely to meet with the approval of the court. As one might expect, legal oversight, whether through the court or through the provision of legal advice, therefore appears to be a potentially valuable form of monitoring, which may protect more vulnerable divorcees, particularly wives, from potentially unfair financial arrangements. The final slide in this batch before we move on to the conclusions is, did things work out as expected? We asked survey participants who had made financial arrangements whether these had worked out as they had expected in terms of being implemented as agreed or decided. First, full arrangements were far more likely than partial arrangements to have worked out as the divorcee expected that they would have done. Secondly, arrangements made through mediation were less likely to work out as expected compared with those reached in other ways. For example, 9 in 10, 90% of full arrangements arrived at by divorcing parties themselves had worked out as expected, presumably reflecting the better relations of those who had felt able to negotiate their own arrangements. 3/4 of full arrangements they made via lawyers at 76%, and also all through a judge, also at 76%, had also worked out as expected. But only 44% of full arrangements made via mediation had worked out as expected. It may be that those undertaking mediation may have already tried and failed to negotiate an agreement made between themselves, so that when they did reach a settlement via mediation, it may have been the result of possibly a grudging compromise rather than a real meeting of the minds, and thus potentially more likely to unravel when it came to be implemented and a party had second thoughts. So, on to conclusions and recommendations. First, the divorcees' lack of financial and legal knowledge. As we saw, there was a lack of awareness of family finances amongst a significant proportion of divorcees, particularly amongst women, in particular in relation to pensions. This was accompanied by a deficit in knowledge about the law and legal procedure amongst the divorcing population. Therefore, there is a need for authoritative, accessible, affordable information and legal advice to provide couples with a clear understanding of what issues they should be focusing on, including the full range of assets, including pensions, that can and should be brought into account. Also, on how to reach a settlement with signposting to appropriate and affordable services to help them. We then divided our recommendations and conclusions into two: use and benefits of the family justice system, so process, and then also achieving a fair outcome, so more substantive law elements. So let's look at the process first. So legal oversight, whether through the court or through the provision of legal advice, appears from our data to be a potentially valuable form of monitoring, which may protect individual divorcees, particularly wives, from potentially unfair financial arrangements. It is therefore worrying that the fear of cost was a factor for 42% of divorcees, both men and women, who did not engage a lawyer or only did so for part of the process. And also, yet contrary to the picture that is often presented, getting a divorce and sorting out finances did not necessarily incur major expenditure on legal costs. For many couples, legal fees need not be exorbitant, and in many cases were likely, as we saw, to be money well spent. Furthermore, the government's preferred mode of non-court dispute resolution, mediation, was a relatively unpopular avenue to pursue, with only 17% of divorcees saying that they had used it and only 12% reaching agreement by that route. Furthermore, as we saw, only 44% of full arrangements made via mediation had worked out as the divorcees expected. Therefore, what we suggest is that individuals need appropriate dispute resolution tailored for their individual circumstances, in particular, which addresses the problem of relationships where there is lack of bargaining power or where there is domestic abuse. Where also, in terms of orders by consent, where parties' financial and property arrangements had been finalised through a court order, women tended to do better in a number of respects. The role of the court, not as a rubber stamp, but as a guarantor of the legal efficacy of the couple's agreement, is therefore an important one that needs to be safeguarded in any reform of the system. Indeed, the benefits of certainty and finality that come with a consent order, as well as the opportunity to check the fairness of the arrangement, suggest that more should be done to encourage couples to obtain a consent order, even where they are in full agreement. So those are the process sides. What about substantive law? First, the importance of pensions. There was a general lack of interest in the pension, as we saw, and a strong sense that it should remain with the spouse who had been contributing to it. And these were the main reasons for the failure to see it as a potential sharing resource in most divorces. It is therefore not surprising that offsetting in the form of trading shares in the matrimonial home was the preferred alternative for many couples. Yet this does not address the imbalance in the total pool of financial resources in the form of income and earning capacity, as well as capital available to husband and wife. Neither does it redress the differences in divorcees' living standards up to 5 years after the divorce. It is clear, therefore, that both parties to a divorce need to be made more aware of the potential importance of pension wealth as a part of their entire asset pool. In particular, the issue of how to deal with pensions needs to be re-examined to consider how it could be made easier for them to be fully factored into the financial arrangements that couples make. What about spousal support? As we have shown, spousal periodical payments are not common and are nearly always for a fixed term, and they are almost always tied to the recipient's childcare responsibilities and vulnerability. There is nothing in our findings to suggest that they are being used as a meal ticket for life for the wife. Instead, they appear to be primarily used to address the individual's need for an additional source of income to cover their adjustment to a new post-divorce living arrangements. Moreover, adjusting to financial independence by increasing hours of work is not straightforward for mothers still taking the major role in childcare of younger children. And for those who do go back to work, life may still be a struggle. In any review of the law, therefore, it is important to recognise how spousal periodical payments are being used by the majority, which is not as a meal ticket for life, but as a vital part of a recipient's income. What about equal sharing? The study has revealed that trying to obtain a 50-50 split of assets proved impractical and undesirable for many divorcing couples when they weighed all their circumstances up, especially when they had children. Our findings suggest that a legal presumption of equal sharing of assets would not deliver a fair outcome between many divorcees, nor reflect their own priorities, given the range in wealth and earning capacity of the divorcing population, and also couples' own differing priorities and circumstances. Indeed, it would be more likely to cement inequality, as between husbands and wives, with mothers and older wives doing particularly badly. And finally, the recognition of financial support for dependent and older children. Now, the moral duty of care towards one's children was clearly demonstrated in our study by parents for their support for older but still not financially independent children. However, the way forward is not straightforward. there would be little point, for example, in extending the duty of support through the child support system if it could not be enforced, and the burden simply fell even further on the parent with whom the older child was living. In practice, more likely to be the mother. But there might be value in extending the duty on the court under Section 25 of the Matrimonial Causes Act to give first consideration to the welfare of children of the family, to include non-dependent children, so that their presence within the family unit could expressly be taken into account. So the final report, the exec summary and the briefing paper are now all available open access on the two sites. Overall, we hope that our findings show that, contrary to popular misconception, or at least the picture presented by the mass media, individuals going through divorce in England and Wales are far removed from the multi-millionaire cases spending huge amounts on legal fees. The picture is not that of a wealthy population, we've demonstrated that, but instead of individuals, couples and families in which their needs dominate. When considering any reform going forward, the needs of these, the majority of the population, need to be front and centre of policymakers' minds. Thank you.
Thank you very much indeed. As I'm very glad I don't have to follow that, but the task of following that falls to Jo Edwards as chair of resolution. Jo.
Thank you. And I have to say, I was just sitting in my chair thinking, how the heck does one follow that? So thank you for saying that, Nick. And I feel, and I'm sure I speak for everybody in the room when I say I feel completely blown away by that. So thank you, Emma and Caroline. Absolutely phenomenal. So yes, I do get the difficult task of trying to follow, and I won't try to follow that in any meaningful way. So I'm here today to try to give a bit of a practitioner's perspective in 5 to 10 minutes, which is going to be quite challenging, but I will do my best. I'm speaking as a family lawyer, mediator, chair of Resolution's Family Law Reform Group. I've also got the vice chair of Resolution here today, and also very, very lucky to have sat on the advisory group for the Fair Shares project. So I've been involved along the way. So I feel really privileged to have been involved in this work and delighted today to see years of hard work take shape and finally come to fruition. I know the academics in the room will completely understand it when I say reports like this don't just happen, and it takes boundless, endless hard work, reflection, dare I say at times being ready to stop and rethink aspects of how data is being gathered, what are the questions being asked, what's the overall direction of travel. So the end product that you see today and you've just heard in an hour is testament to all of that and more, and means that we can have huge confidence in the robustness of the end product as a foundation for future discussions about financial remedies reform. So today should rightly be about Emma, Caroline, Gillian, Susan and Jenny not here today, but them also, and all of the blood, sweat and tears that they have put into this project. I had got a note to self to pause for applause here, but you very kindly made me start. So more applause. So the practitioner's perspective. Those of us who work in this area will share the frustration which existed up to this point about how little was known about the process by which divorcing couples settle their finances, and the fairness of those arrangements, especially among those who reach agreement outside of the courts. We've also seen, I don't want to sound too self-serving here, and it's difficult not to, but we have seen our profession at times criticised in the media headlines about sensationalist cases with eye-watering levels of fees and outcomes which seem objectively difficult to justify. Now, I don't want to apologise, I'm sure there are lessons to be learned from those cases, but we should celebrate today's report, both because it addresses the knowledge gap about the cohort of people reaching agreement, as I put it, under the radar, but also because it looks at the more run-of-the-mill cases which don't make the headlines, and in doing so challenges and debunks a lot of the myths about splitting assets on divorce. We all know, and it's a cliche, that hard cases make bad law, but now really is the time to look at the experience of the majority, not the minority. And again, this is what this report does in spades. So picking out highlights from a report which spans, I think 394 pages was the final count, or as Emma said earlier, 125,000 words, felt nigh on impossible when I came to revisit it last night. And it's really rich with material when you come to read it, which will speak to different cohorts of people in different ways. So I just picked out 3 areas, and I'll try to be brief. So the first one, and Emma has covered this in spades, particularly in her conclusion there, the use of lawyers and the value that using lawyers can add. Again, I risk sounding self-serving, but it really struck me to learn that only 32% of divorcees had made use of legal services in relation to financial arrangements, with 42% of those who didn't saying they'd been deterred from doing so by fear of cost. Yet where legal or mediation costs were incurred, as we've heard from Emma, they were relatively modest. I appreciate it's easy to sit here, look at figures and think, well, they may sound modest, but to the person going through the divorce, they're not. We've heard about the median value of case being £135,000. So I bear that in mind, and I don't want to underestimate how expensive it will be for people to find £1,000, £2,000. But in relative terms and relative to the headlines we see, the costs were surprisingly low, I thought. And where matters have been finalised through legal support, through solicitors or with a court order, there was evidence, again, as we've seen, to suggest more positive outcomes for the applicant, especially in relation to pensions and ongoing financial support. So in all of that, I think there is a lot for us as practitioners to reflect upon, especially, and it's a conversation we've been having for some time now, but in how we package up and price our services to be more accessible to all, and also how we convey the value add as practitioners, not only to divorcing couples, but also to government in the context of campaigning for funding for initial legal advice, something which resolution has very heavily got its teeth into. If we did all of that effectively, I wonder whether we might actually reach some of the 36% of divorcees who didn't make any particular financial arrangement with their ex on divorce, or indeed potentially improve the outcomes for more of the 52% of those who did reach a financial arrangement but did it in a DIY way. Secondly, and I speak as a mediator, we do need to think about what's said about mediation. There's clearly some ongoing confusion among the general public about what mediation actually is. We know, and again, this has all come about, we'd say, as a result of LASPO, and we know it from LASPO, but the fact that the strongest indicator of referral to mediation is where a solicitor was involved. And then we hear, and it's quite difficult to hear, the evidence of some dissatisfaction with mediation outcomes years after the event, with that statistic only 44% of those who'd made their arrangements through mediation saying that they had worked out as they expected. So I think lots of outcomes from that for me. It feeds into how we as mediators explain mediation, how we robustly ensure that we filter only appropriate cases into the process, and how we ensure that there is a more joined up DR offering, appropriately packaged, appropriately costed. We also need to ensure that we continue to tell government, who have a tendency to focus on mediation as being a silver bullet and to the exclusion of all else, that it isn't a silver bullet, and that properly timed and funded legal advice, together with couples having a voucher to cover and to use for whatever DR process may be most appropriate for their case, is the better way. And then thirdly and finally, in terms of take-homes from a 125,000 word report, in terms of substantive outcomes and what the report tells us, there's a lot of material in there for practitioners to reflect upon, including what drives couples in their decision-making around financial outcomes, and the fact that they may sometimes be motivated by emotional rather than practical considerations. Lots of evidence of that, for example, the continued low take-up of pension sharing orders, as you've heard, the focus by many women in particular on keeping the family home rather than perhaps thinking about longer-term financial outcomes for them, and the overriding keenness to have a clean break with spousal maintenance in only 22% of cases. Note to self, there's so much for the supposedly pervasive meal ticket for life. It just isn't borne out in practice. So the report offers insight into the unequal financial footing of parties going into and coming out of divorce. And we must reflect upon the advice we give to try to temper this, especially where clients may only interact with us fairly fleetingly if they are concerned about costs, and we know that they are, and accessing unbundled legal services. In those circumstances, we've got a really short period of time in which to actually grab people's attention and make them realise really what potentially they may be missing out on. Now, in all of this, it will be interesting, but I just sound a note that I've been keen to think about personally. Interesting to see the impact of the move to online and no-fault divorce. So as you'll all be aware, all of the participants in this study I know were spoken to as people who divorced under the old law. And I wonder whether the relative simplicity of the new law will make it even less likely that people will take legal advice, with consequential impact on financial outcomes. So I think this is something that policymakers will need to be aware of and be alert to. And as an advisory board, I know we've warned Emma and Caroline and all that we will expect to see Fair Shares Mark 2 in coming years, so we can see the impact of that. So as the Law Commission reviews the laws implemented half a century ago, it is important, I think, that we bring our own experience as practitioners to the table. We know that when law reform is being considered in any area, such as with no-fault divorce, a successful campaign depends on several key ingredients, including the evidential basis, which you see today, the practitioner perspective, having real-life examples of the difficulties caused by the existing law, as with Mrs. Owens, learning from experiences of other countries, and getting media interest and support. Whilst I won't prejudge the Law Commission's work, speaking for myself and, dare I say, with the benefit of this report, I'm not sure that wholesale reform of financial remedies law is a pressing priority ask. Using the Fair Shares report, we should be looking more closely at what is working for the average couple going through a divorce, what needs fine-tuning perhaps, and reflecting upon whether more principled discretion, together with reviewing process and access to joined up information and timely, affordable advice, will mean that couples will be even better served by existing legislation. On a personal note, and those who follow me on social media will have heard this in spades, I was born in 1973 and I turn 50 tomorrow. I suspect that the Matrimonial Causes Act has stood the test of time rather better than I have. So, to finish off and conclude, to the practitioners in the room, I say, engage with this report, read it closely, and reflect upon and share your own experiences to help shape how things could work better for couples. I know the Law Commission are very keen to hear from us. To the Law Commission, I say good luck with the detailed piece of work upon which you're embarking, into which this research will feed, and for which we're all grateful. And to Emma and her team, again, I say congratulations on a truly seismic piece of work, and one which will properly move the conversation away from the high net worth couples who make the sensationalist headlines to the average couple who just want to sort this stuff out and move on with their lives. We're truly indebted to you for this report and for filling the huge knowledge gap that until today existed in this space. So again, thank you.